Seoul is one of the international city, as far as I believe. I'll just do.
Well, we after this presentation, we will all want to visit and learn more about the legal system. First of all, by way of introduction, let me welcome you to our lawyers' meeting. This time will be held in English, so I hope this is okay for everyone. Okay. And thank you again for willing to give us a presentation on the Korean legal system and about your online practice in particular.
Yeah.
We'd be very curious to hear about this because you are part of an online project-based consortium premium law firm, and that is something that I think you need to explain to us.
Okay.
And because we of course are very much interested in learning what the future legal practice will look like, and this looks to me like we are looking into the future. So over to you, and thank you again for doing this, for making this presentation to us, and we look forward to learning something about the Korean legal system.
Okay, it's my very pleasure. First of all, just even if you are very busy, but I'm very pleased to meet all of you in this room, prior to my making presentations, I just simply express my thanks to the Dr. Blau, who just invited me to stay here. Even if it's not so long time, but during my stay at this very prestigious law firms, I learned a lot, and I'm learning, and I will learn a lot in the future. And right now, I would like to introduce some kind of pending controversial legal issues which happen in Korea in terms of specific legal issues or legal administrative matters, etc., etc. And because I'm also involved as a vice president of Korean Bar Associations, and therefore, rather than just the specific legal issues, also I'm interested in the legal administrative matters, and also I'm not native speakers, and therefore I would like to get some understanding about what I try to explain to you. And if you have some problems, just please let me know. So first of all, and this the slide shows just a brief overview on the pending legal issues in the Republic of Korea. I'm a little shocked because nobody in these rooms have visited Seoul, and therefore I think you do not. I do not think you have very much information about the Korean legal systems, and I just stick to the basic matters. Okay, and first of all, the index is I explained to you about the legal systems and the legal education because of the radical some changes in Korea, and just to briefly explain is we adopted the international legal systems like German, and our legal system is based on German legal system, and partially adopted the French legal systems, and also some Japanese legal systems. And legal education is basically almost previously the same as German legal system, but we recently changed our legal system, education systems. We adopted the law school systems, and therefore there are some kind of big change in the legal world in Korea. And also there are several problems between the lawyer and the other legal professions, like patent attorney, because there are some kind of history backgrounds, and I just explain to you about the matter. And also I get some kind of very constructive input from your country's laws and practice. And so on is just maybe this is a kind of some contributing issues, and just randomly I pick up some issues on an issue basis, and I just have some kind of time to share your inputs and comments in this regard. And so this is my favorite how can I say subject. I'm interested. I'm just a senior vice president of Korea Arbitrate Associations, and I'm future next year I'm just next president of Korea Arbitrators Associations, and therefore I'm just feels very obligated to just explore some kind of how can I say the possibility that the Korean Arbitrators Associations have some kind will play a major role in this world. Because I'm not an ex-judge, and therefore I'm just more interested in the arbitration proceeding rather than court proceedings, and also more flexible and in terms of cost and the time. And I just prefer the arbitration. When I go to the in Korean court, always I just feel it's like I just went to the just 18th century's world rather than just the 21st centuries. And also IPs. Also, I'm just the presidential counsel on the IP matters, and therefore I spent 2 years as the presidential counsel on the IP matters, and I'm just interested. Also, this year, this semester, I had a chance to deliver the lectures on the IP laws and the practice of Korea at the Kaiste University, which is one of the best universities in Korea. And therefore I'm quite interested. Opening Korean legal market, I think you are a little interested in this practice. Currently, we just totally opened to EU lawyers and law firms, and you can easily establish your entity in Korea. And nowadays, the senior partner is Dr. Mr. Tedman told me that I'm interested in the online law firm. But currently, I belong to one of the just how can I say oldest law firm, which is for Kim Jang and me. But I just thinking about the just which is online law firm, which is a kind of over law firm. And also in Korea, I'm a little shocked, a little surprised. Is a Korean adopted electronic litigation system, and therefore every filing will be done on an electronic basis rather than just a paper basis. And therefore I explain to you, and others maybe will have some kind of Q&A sessions. And yeah, as I mentioned before, we just adopted the continental legal systems, almost the same. Civil code, and criminal code, administrative code is almost the same. Maybe some kind of variations, but basically I think it's almost the same. And the second one is we just we unlike the Anglo-American systems is there just the court judges make a rule, but we just like the German legal systems, the legal authority is based on the statute, and just the function of the judge is just to interpret the court. And we do not have any federal systems, and just only we have three tiers, the strict, appellate, and the Supreme Court levels. But we have some problems. We also adopted the Constitutional Court and the Supreme Court, as like you. But only the problem is there's some kind of tension between constitutional law and Supreme Court. For example, constitutional court will have the authority to decide whether or not certain code or statute is constitutional or unconstitutional. That's all. But Supreme Court has authority to just how can I interpret the statute, and therefore, it's okay. The Constitutional Court said that if this is unconstitutional, it's okay. But after that, who has the authorities? Who will decide? Who interpreted the statutes? Which is unconstitutional? That is some kind of the interpretation, and the position is a little different, and therefore some kind of some tensions and that is a problem. And the prosecutors and the versus police, we have I understand you are also very strong prosecutors authority, powers. In Korea it's the same, but it's too much, and there is no control. There is no government agency to control over the prosecutors' powers. The police is just a kind of, they are obligated to, how can I say, comply with the instruction from the prosecutors. And therefore, there is a problem in the politically and the socially. And now you are just currently you are facing some kind of and this one is a little. I would like to get some kind of conservative input. Just we have some kind of little tip. Is a little from how can I say different systems. Yeah, judges they just before prior to the retirement age, just retired and then they can be a good lawyers and they make a lot of money, and that is a big problem. And therefore, when I was the vice president of the Korean Bar Association, that is a problem. And we said it's like some Supreme Court judges retired, and just we asked him not to practice law as a lawyer, even if it's not private, because it's like in Korea is after the judge kind of doing business, and therefore that is a problem. And therefore it's like we are judicial reform. We are thinking about the judicial reform in daily life. And that is currently our contributions. And like your countries, we had originally patents based on the qualifications, but now we adopted just law school system, which is how can I say work in the United States and moving into law school system, and also some kind of restriction on the number of called law school graduate to take the patents only 5 times, and that is also some problems because even if they cannot pass the bar, that is serious problems. But because recently around 8 years ago we adopted law schools, and therefore currently there is no victims of this kind of system, but later on it will cause some problems. And as I mentioned before, judges kind of elite character. So they are the colleagues of the judges, and even after being retired from the judges, he practices laws and problems. And therefore, we just currently we are facing judicial reform. And another issue is like patent. In the fourth industrial revolutions, IP is very important. But currently, when I was a lawyer, it's 1980. When I was a judicial apprentice in 1983. At that time, only number of lawyers were 1,000 or 2,000. Now it's over more than 20,000 lawyers. And therefore, everybody lawyer at that time, everybody happy. Nobody wanted to. It's like tedious work. Just to go to the court and then they have paid a lot of money and they don't have any problems. And therefore, there are another some kind of legal profession which is for the patent. And it is not a lawyer, and but a kind of agent. But they are very highly sophisticated in this area, in these fields, and also therefore, I think there is some kind of now they are eligible to attend the how can I say IP court, and therefore that is a kind of cause some problem. And here is a little very hot issue, but I do not think you will have this problem. But later on, just I get some kind of some considered input into that. And now, just to move on to the specific issues. I guess you also have some this kind of problem. Just currently the problem is damage claims. The courts recognize only small amount of damage and too low, and everybody they are not satisfied with the compensation, which was landed by the court judges, and they go to the criminal stage, and then they go to the criminal case, and then they push the wrongdoers to come to the settlement. Otherwise, they will put in the jails, and therefore it's a kind of some kind of the burden to the function of the judicial function, and therefore it's a little problems. And therefore nowadays I think you are also, your system is not reluctant to adopting the punitive damage in terms of various, on various reasons, but you are very a little more flexible. Recently, product liability cases, we just adopted punitive damage claims. It's another 3 times actual damage. And also, we think that this adoption of punitive damage is have some kind of positive effect on the prevention of the misconduct. Because, for example, someone just like vicarious, it's like just negligent, he just hit someone and resulting in the damage, and someone grossly negligent hit someone resulting in the damage. But it's in the if we do not use this punitive damage, just the outcome is the same. Maybe a kind of distraction of the judges, but if you use these concepts, maybe quite how can I say, effective and very useful concept, and you are very willing to expand this kind of the concept punitive damage in the various cases. As far as I understand, in the United States, around more than 100 or 200 codes they adopted the punitive damage, and also this is also very controversial because for the companies to be more competitive, they should the kind of establishment of government corporate governance is very important, and therefore the major role will be played by the institutional investor, and therefore we are just there are some kind of dispute, but we are nowadays in Korea very you are just more how can I say optimistic or just how can I say affirmative views on the exercise of voting right by the institutional investor like national pension fund. But recently, some kind of political influence was involved, but it's not so good. But generally, it's like the trend is like more active and exercise of voting right by the constitutional institutional investment for the purpose of establishment of corporate governance, and some kind of status code is also is now recently enacted. And adoption of the poison pills, like a kind of a defensive device in the hostile M&A transactions. But nowadays we have some kind of bad feeling about the owner of the conglomerates who has low sharing ratios, and they just try to keep their management positions, and therefore generally it's like general view is very against defensive device such as poison pill, etc. in the hostile M&A transaction. But for the startup business, I think this device should be useful to maintain his management the power, and therefore now is like currently Korean current government is very how can I say affirmatively take into consideration the adoption of this kind of defensive devices, and also wide application of the consented order. I think this is widely applied in the euro market, FTCs, and this is a kind of innovative concept, and therefore now is that you are expanding this kind of concept. But I guess we learn something from your system, and or EU or FTC implementation of the how can I say fair trade related regulations. And the public notice issues, because I am just a public notaries, and quite different. For example, in the United States, only even he's not lawyers, just 2 judges recommend him, then he can be a public notaries. And it's cost a lot. It's very simple. It's only $3 just get some signature from the public notaries. But in the continental relation, it's quite different. And here, I really shocked. And only one of the founding partners and only few just the senior partners is public notaries. And therefore, I'm just curious about that. Now is Korean also. We just utilize the public notary as a kind of, how can I say, outside judges to solve some the dispute, even if it's a kind of vacations issue, the litigations, maybe just it can be done through the signature from the public notaries. And also, we have some kind of dual legal systems in adoption of the class action, these corrective actions. In the consumer litigations, we adopted the German style, and then it's a kind of class actions, but it's not widely utilized. But I think the class action should be more utilized, because only the surplus will. The issue is surplus will who take the surplus. For example, if you adopt class actions, and the surplus will get by the consumer or victims. But if we do not adopt the class actions, then maybe everybody should bring a lawsuit. Otherwise, he can get anything at all. And therefore, you are very is more affirmative. It's just how can I willing to adopt these class actions, but still, just a few sections like we adopted class action is not how can I say justifiable, and therefore you currently just thinking about this the pros and the cons between two systems, and but you are very some scholars just very how can I say strongly argue that we should adopt this U.S. class actions, because even if we adopt the class action, it doesn't negatively affect the consumers' rights, and therefore as far as I understand it makes sense. And also, this is very interesting case. The Supreme Court cases is in Korea, it's like continuous fee arrangement is legally permissible unless it is too substantially unfair to the client. It's okay, and therefore it will be reviewed case by cases. But recently, very shocking, the Supreme Court decision. They said actual cases, the contingency is the fee was around $100 US. The court said in actual cases there's $60,000 will be sustainable, but exceeding the amount is in excess of such amount will be nullified. But surprisingly, they express some kind of opinion that said, but this kind of contingency fee arrangement in the criminal cases poses some social serious problems, and therefore now in the future any contingency fee arrangement in the criminal case will be nullified. They express some kind of opinion, but it's not, as far as I understand, it doesn't make sense. But anyhow, just we are very shocked, and therefore currently, because he expressed, the Supreme Court expressed that any contingency fee arrangement in the criminal case will be nullified once we already put into the notice ordinary person and including the lawyers, and therefore just there is no actual cases, and but nowadays in criminal cases no contingency fee arrangement here. But I'm just talking about this kind of court's decision, court's opinions cannot have any legal meanings, but actually in practice it's true. But I'm just a little wondering why the Supreme Court take this kind of position. It's a kind of function of the constitutional court cases, and therefore just is a little nowadays a kind of some because we do not have many experience on these matters, and therefore I think this kind of position was taken by the Constitutional Court. Yeah, it definitely makes sense, but because the Supreme Court take this kind of positions, and therefore we are a little confused about that. And current pending issues and the future outlook of the ADR. But this is only, I would like to skip this part. But basically, my saying is this is a kind of nowadays arbitration is a kind of industries. We recognize arbitration is already industries, and therefore we recently enacted the special act on promotion of arbitration industries, and then the government agencies changed from the Ministry of Trade, Industry and Energy to the Ministry of Justice. And also partially they are also involved in the supervision, the exercise of the supervision. And also this is very important. I'm just the vice president of this part, corporate Korea Arbitration Associations, and therefore I believe that the Korean Arbitration Association play a major role in just the promotion of the arbitration industry. But that is my personal opinion on that. And this is a little quite interesting because I'm not a judge, and therefore I prefer the arbitration rather than the court proceedings, and especially in the sports law and also some kind of IP area. It is arbitration is very effective in terms of cost and time, etc. And I just skip out. Yeah. And IP is like currently we think the IP is very important in facing the fourth industrial revolution, and therefore IP financing is very hot issues because in order to boost the IP industries, financing is very important. Two models. One is China, and the second one is United States. We are China is more taking conventional banking just activities, like they get they put some kind of how can I say they just loan transactions, and in United States a kind of investment style how can I say capital injections in utilization of the venture capital. But anyhow, nobody wanted to just inject capital just to the only startup company, which only has just IP assets, and therefore some kind of government assistance required. And I think, as far as I understand, China is had done a very good job in that regard. And also, this is beyond patent and the software patent. Two approaches possible. U.S. is more stringent, and China has recently allowed them alleviating the regulations in that regard. And therefore, I think this is very important part. And also, there's a contract issue in Korea. And also reform of the employees' inventions. And this is in Korea is basically the employees' inventions, any inventions which employees have created in the course of how can I say his duty, then just it belongs to the employees, and then in a certain process, just it can be transferred to the company. But the process is so complicated, and therefore IP M&A deals is very big issues, and therefore recently government changed this process, and basically make it simple, and then also maybe rather than the employees just directly go to the companies. The employees are always interested in the suitable, appropriate compensations, and therefore to ensure the appropriate compensation, then I think it will be okay. And therefore, just currently, just the draft was submitted to the Congress, but is not yet finalized. And also, reform of the copyright. In Korea, it's like there is some kind of, in copyright, there is some very interesting expressions. Just copyright work means kind of creation of human, which express human thought and emotions, and therefore nowadays AI creations. AI then, under the literally speaking, literal interpretation, it cannot be protected by the Korean copyright laws, and therefore it should be changed. And also, AI is like they just utilize various data, and therefore it means a kind of copies, and therefore utilize various existing data, and they may create something. Then it can also cause problems, such as copyright infringement, and therefore that is a problems. And in that regard, the Japanese government is very very just very active provisions in changing just the amendment of the copyright law in order to amend the related laws and the IP court jurisdictions. Recently, because of the some kind of dispute between the judge and lawyer and patent agent, 5 state courts exclusive jurisdictions and the major 5 cities, also they have only the jurisdictions. But it's a little. But recently, as you may be aware, recently the U.S. Supreme Court held that just only the court who has just the jurisdiction of the dependent domicile will have exclusive jurisdictions. And previously, the previous appellate courts of the United States said just a kind of business activities happened, then that court will also have jurisdictions. But now they changed, and also you have some this kind of also problems. But the reason why we just amend this kind of private district court jurisdiction is just to enhance the expertise. How can I say it? How can I speculate? How can I say it? Enhance the expertise about the IP, but it doesn't work because, like in Korea, every judge, unlike United German systems, like the periodic period, just some judge who work in the Seoul District Court, he should move into another provincial area, and then 2 or 3 years just move into another areas, and therefore it doesn't work very well. And therefore there is problems. And now I'm just talking about this part. This is a general provision under the Unfair Competition Prevention Act, and as you may be aware, IP is like the important is idea versus expressions. If some just how can I say a work just is considered as the expression, it can be protected by the IP related laws, but just the idea cannot be protected, and therefore there is a very serious problems, and therefore there is some kind of something happens just between idea and expressions, and there is no way to protect such kind of thing. But recently, I think the model provision is come from the one in the German Unfair Competition Prevention Act. That is what I understand. But if I have something wrong, please just correct it. But the problem is like we have this kind of provision. Any other act or infringing on other person's economic interest by using the outcomes, etc., achieved by them through through substantial investment or efforts for one's own business without permission in a manner contrary to fair commercial practice or competition of others, then it can be the unfair competition practice, and therefore it will pose civil or criminal liabilities. And therefore, the only problem is like the judges love these provisions always, and if you have same problems, just they apply these provisions. And there are some scholars just criticize such kind of tendency, because sometimes it's like the court is like it can be protected by the copyright law, also it can be protected by this unfair competition provision, and therefore maybe some we think that possibly you have some problems in this area. And also MP is like you may be patent troll, like a non-practicing entity. Here we do not have many MPs, and therefore they just play a major role in the IP transactions, and just we how to boost the MP, just vitalize of MP, but we should also just regulate it to excessive abuse of their power. But now it's hard issues, and also the important thing is IP market vitalizations. Then maybe we just get some kind of accurate IP evaluations, and IP chemical is like some kind of IP. If the financial companies get IP as a priority, then maybe just right now no more is values. Then some company should buy these ones, and therefore we need just assure that we should adopt the IP control and IP insurance companies in order to securitization of the IP assets. Maybe just some kind of this kind of insurance companies help will be helpful to vitalize the securitization transaction of the IPs. And the patent right, you may be aware of the incentive, the tax incentive the devices, but unfortunately, United States did not utilize this kind of patent structure. It is widely utilized in the EU market, but also you are sometimes, even if you are taking into consideration adoption of the patent box, still it does not progress. It's like in progress, and therefore maybe that is also a problem. Understanding one and preparation for the e-discovery. And I think it's, for example, so if they just provide some kind of e-related the evidence by gross negligence or intentionally, then just the judge will admit it. They say that just the defendant admitted the allegation of the plaintiff, etc. And therefore, we are not used to this kind of mechanisms. This is a very powerful in United States, and therefore we have some have serious problems. We are not well prepared for this kind of e-discovery process, and therefore that is also very contribution in Korea, and opening Korean legal market, and currently definitely we through the EU FTA, and therefore currently I guess last year we already completely opened the legal market to EU company and EU lawyer, EU law firms. And also they hired the Korean lawyers, and also they established the joint venture companies along with the Korean law firms. But the Korean law firms' shareholding ratio is restricted up to the 49%. It means like Korean law firms do not have managing power, and there is problems. And many Korean Korean law firms and complaining about that matters, but currently it's under negotiations and maybe can be a little changed. But currently any affiliations and set up some of the branches and or some kind of joint establishment of joint venture fully possible in Korea. And but a lot currently there are a lot of foreign law firms who opened their office in Seoul, but now it's becoming increased. And online office justice is a kind of, I said currently I'm just offline law firms. I'm just a part of some kind of partner, or maybe possibly a senior partner level. But I'm just thinking about the establishment of the Uber type law firms, because Uber is like they just install some kind of apps, and every, how can I say, businessman like taxi driver, and then the Uber app just collect some kind of commissions for their revenue, and but they do not, Uber app do not have two parking facilities and also repair persons, etc., etc. And that is very cost effective. And therefore, this kind of trend will be definitely, just how can I say, utilized in the legal market in the future. And therefore, this is a very important error. And if you just put some kind of app, and then everything is like many various law firms and lawyers like connected on a project-based contract basis. And now it's like most of the lawyers in these firms, you have a lot of lawyers, most of them is arranged in the employment basis. Then, for example, associated, but generally they are guaranteed to get the certain regular how can I say, salary, then there is not much incentive to work hard. But in this contract base, it's quite different. Depends on should do their best to get much more incomes. Otherwise, they cannot survive at all. And therefore, it's an inevitable phenomena in the legal market as well. And therefore, I think that this kind of where is at and the various the nationwide and worldwide, it is very important concept because they costly effective. And nowadays, as I mentioned before, now you are electronic litigation systems, and therefore you don't have to face-to-face meetings. Maybe through the apps, and they get us inquiry on the online basis, and just dispatch to the member lawyers and law firms, and then just on the online basis they just co-work, and then just outcome will be released to the client. But maybe some parties are a little difficult, but generally the trend is like that, and therefore this kind of network, not employment and contract based, especially project based, this arrangement very important things, and therefore. It's like nowadays, like the location is not a big deal because it's online basis. They can easily communicate with each other, and therefore that is my future plan, and that is my just a kind of as far as I understand, UOF will be also utilized in the legal market, and I should be prepared with that, and therefore. This kind of my experience during my stay at your procedural law firms will be very helpful to get some ideas and etc. And because time constraint, I'm just trying to just speed up the process. I did my best, about maybe it's not sufficient. But if you have any questions, maybe would you give me a question? And I just.
Thank you very much, Mr. Gill. Thank you very much. Thank you very much for the excellent presentation. And I open the floor for questions. And I have maybe I can start with one question referring to the online law firm that you just explained. Is there a requirement for a physical presence in Seoul if you want to be admitted to the bar, or how is that regulated, the online firm?
That is it's a very, very important comments about that. But for example, it's like the location. For example, German lawyers through the online law firm systems, they provide some kind of opinion about the Korean laws. I think under the current regulation, it can be a violations. It poses problems. But in cooperation with maybe it can be just it cannot be serious problem because like a law firm means it's like a legal entity which was authorized to practice law in law firm's name, and therefore regardless of the how can I say the members. Or some kind of people who belongs to the law firm, it doesn't matter. But for example, it's like Attorney Goodman just expressed some kind of legal opinion about the Korean legal issues, and then it was just released to the client. But then, even if such kind of legal opinions was expressed on the name of the law firm, online law firm, which was it's like, located in Seoul, but it will be some pose problem. But I think maybe make it because you just want to provide some kind of comments, and then just collecting all the ideas, and then finally the online law firm, which was authorized to practice law in Korea.
Mm.
They provide some kind of legal opinion about the Korean legal matters. Then I think it's okay. And but you are right. And how in the organization of the law online law firms on a global basis, that will also we should keep in mind, and maybe some kind of because that is a little loophole, and maybe. But I think we make it. And for example, Uber is also is a problem. It's like they provide just some kind of, because they do not have a business the driver license on business, but they just they conduct this kind of business activities. And in the Euro, so like Uber is not so successful in the United States. But frankly speaking, current regulation is more oriented to the offline environment. So therefore, this kind of will be changed in the future. Not some part, is essential part, is still exist, but other than the essential part will be changed. But I'm just, that is a very important comments, and that is, we should keep in mind, and also how to protect the online funds, and which possibly expose themselves to such kind of regulation risks. Therefore, maybe your lawyer said you can make I believe.
Okay. Further questions?
From your very personal experience, where do you see the system, the legal system in Korea develop into? More the civil law system similar to Japan and Germany, or more the common law system as in the US or the UK? What would your expectation be, in which way your system will develop in the future?
Yeah, very. It's a little difficult. I'm not sure that I'm the right person to say something. But you're asking the personal opinions, and
yes.
But it's kind of maybe not directly. For example, the civil law system will survive, and the common law will perishing. That is not, I think, the right issue. But for example, punitive damage concepts is a very innovative concept, even if just it was created by the American legal systems. Because we are little. For example, like someone hit another person by arm, by negligence, just negligently, and another one is like gross negligence or intentional. Then the responsibility should be different, even in the civil law. But here, in the civil law systems, it's quite, we don't care about the degree of his carelessness. But it's quite different. They just treat differently. And therefore, in that area, very helpful. But basically, I prefer, for example, just the general concept is, I think the civil law is like more very broad and more flexible legal systems. And then some specific part, I think such kind will be incorporated into the civil law systems, because it's too much complicated. Because Anglo-American legal systems, even if they spend 3 years in the law school, they don't know what law is. That is problem. Yeah, that's true. And therefore, it works. Juries may make some kind of decisions. We cannot differentiate factual matters from legal matters. Sometimes overlap. And therefore, some very, sometimes some ridiculous, sometimes some the decision we cannot understand. And, but it's a kind of, I'm biased, but basically, generally, it's a civil law system more effective. But maybe we should adapt some kind of useful concepts from the system. But that is all.
Maybe one more question before we bring in the sandwiches, and when we can continue the discussion over lunch? I would, if no one else has a question. So can you maybe explain to us how are fees charged in Korea? What is the
Fee arrangement?
fee arrangement? What is the standard fee arrangement in Korea?
Yeah. In Korea, it's like normally, conventionally, it's lawyers only few lawyers, and just they go to the court and just make pleadings, and then two systems. One is initial down payment, another one success fee. That's all.
Okay. Initial down payment?
Yeah.
And down payment based on what?
It's like the difficulties of case, but there is no clear-cut standard.
Okay.
And just to say, it's like normally.
Okay.
Market is like that.
So down payment and then is success fee, basically continued.
Yeah, litigation. That's why this way. Nowadays, like law firms, many lawyers adopted the American system, and therefore hourly basis fees. But nobody, client don't like this kind of fee arrangement. They cannot control it, and they hate. And therefore, we normally just set some kind of ceiling, and then based on the hourly basis. Because it's a more, how can I, client oriented. The client like it. Just to set the ceiling. Yeah, I don't pay too much money in excess of the ceiling. Then if the load is less than the originally expected, then maybe just the client does not have to pay too much, and therefore that is a little standard form.
Okay.
But I think nowadays, like legal market is now is a buyer market. Previously, it's buyer market because it's like most of lawyers are the ex-judges and she knows judges and prosecutors, and if just the client make him angry, we just pay a little. It's not comfortable. And but nowadays changed, and now buyer market, and therefore a kind of qualitative device such as ceiling, and still even if we law firms charge the client on an hourly basis, but still the client don't like that, and therefore we should set some ceilings. Otherwise, they don't like such kind of arrangement.
All right, thank you very much. I think it's time for lunch.
Okay, thank you very much.
Thank you very much.